Greetings to you, and welcome to our Acton Lecture Series. My name is Stephen Barrows, and I'm the Managing Director of Programs here at the Acton Institute, where our mission is to promote a free and virtuous society characterized by individual liberty and sustained by religious principles. We begin this Acton Lecture Series by streaming a talk from our speaker, and this will be followed by about 20 to 25 minutes of live questions and answers. Questions can be submitted as comments in Facebook Live or sent via email to digital@acton.org. So without further ado, let me introduce to you today's speaker. Mark Janus is Senior Fellow at the Liberty Justice Center, where he and his colleagues fight for the constitutional rights of American families, workers, advocates, and entrepreneurs. Mr. Janus hails from Springfield, Illinois, and his career has spanned both the public and private sectors. For over a decade, he served as a childhood support specialist for the state of Illinois, where he was also compelled to pay fees to the Public Employees Union, the American Federation of State, County, and Municipal Employees, or AFSCME. Fighting for his First Amendment rights and the rights of 5 million government workers, Mark was the plaintiff in a lawsuit against such compulsion, which culminated in a June 2018 Supreme Court victory in the case Janus versus AFSCME. In summarizing its decision, the Supreme Court declared, quote, "Accordingly, neither an agency fee nor any other form of payment to a public sector union may be deducted from an employee, nor may any other attempt be made to collect such a payment unless the employee affirmatively consents to pay," end quote. And so I'm delighted to welcome Mark to discuss his journey towards this court victory. Let us now turn then to Mark's lecture, after which we will open it up for questions and answers.
Well, thank you. It's such an honor to be able to speak with you today, even if we can't be together in person. You know, it's kind of surreal providing this lecture to you virtually. I mean, who would have thought just a few months ago that we would all be attending seminars in person, and we'd be working in our offices and socializing in person, whether it be our backyards or, you know, the local restaurant, without regard to masks or social distancing. You know, in fact, the past few years, my entire experience surrounding my Supreme Court case has been a bit surreal. I mean, I never set out to be a Supreme Court plaintiff, to take on, you know, the government unions, some of the most powerful political interests in the country. I mean, I'm just a regular guy from Springfield, Illinois. And for those of you that don't know a lot about Illinois politics, Springfield is a strong union town. Illinois has always been a strong union state. So like a lot of people from this part of the state here in central Illinois, I spent parts of my career in the public sector and parts of it working in the private sector. In the 1980s, I worked for state government. At the time, I didn't have to pay any union any dues or fees just to hold my job. After a few years, I left the government to work in the private sector. Then in 2007, I returned to state government to be a child support specialist. And that's when I learned something had really changed. When I got my first paycheck, there was a line item for union dues. Wow, that was a surprise. I started asking around and soon learned that in the 3 years and in the many years since I had left my job in the 80s, Illinois politicians had granted government unions the ability to deduct money from almost every state worker's paycheck, even if they were not union members. Not union members, they still had to pay. I never signed a pledge card. No one ever asked me to join the union. Nothing was ever really said. I didn't want to have to pay a political organization in order to do my job. And nobody asked me if I wanted to. But because Illinois didn't have a right to work law, that's what I was forced to do. Every year I was required to give AFSCME, one of the most powerful and political government unions in the country, hundreds of dollars just so I could keep my job. Well, to me, that just wasn't right. I mean, I watched the dollars come out of my paycheck week after week, month after month, year after year. Finally, my frustration reached a boiling point when the union threatened strike if they didn't hand over $3 billion, yes, folks, that's with a B, billion in higher wages and benefits. Now, why would that make me so upset? I mean, everybody wants a raise. Wouldn't you want a raise? Well, if you've heard anything about the state of Illinois, you probably have heard that even before COVID-19, the state was broke and their junk bond status was almost there. I mean, it was above junk bond status, but getting pretty doggone close. Now, the state can't afford day-to-day operations. They can't afford their daily expenses, much less $3 billion in increased wages and benefits. And to think AFSCME wanted workers like me to walk off the job if taxpayers in Illinois didn't fork over the money. I mean, I was not a union member, but they wanted me to walk off the job. I just thought that was totally crazy. That's when I knew I had to do something. As Whittaker Chambers said in his book, Witness, men must act on what they believe right, not on what they believe probable. But what could I do? I couldn't take on the public sector unions all by myself. I mean, I was just one person. I was tired of being treated like an ATM machine. I mean, forking over money, paycheck after paycheck, just to hold my job. So I met the folks at the Liberty Justice Center, found out they were a public interest law firm, and they fight for individual rights and freedoms and individual constitutional rights. They fight for the cause. They don't fight for money. They don't fight for any special interest. And when I started talking to them, I realized they could help me and that we had a lot that we agreed upon. So that's why I asked the Liberty Justice Center in 2015, in the spring of that year, to file my case. Then the waiting began. I mean, court cases don't progress as fast as they do on TV. It was a waiting game. I soon learned of another case, almost identical to mine, that had been filed in California by Rebecca Friedrichs. Now, it was decided to hold my case to see what the outcome of Rebecca's case would be. Unfortunately, after the Supreme Court arguments, but before the decision was rendered, Justice Scalia tragically passed away. This passing of his resulted in a 4-4 tie or no decision. My case became very important to carry on the fight for worker freedom. As my case made its way through the court system, I continued to work for the state of Illinois. For somewhat obvious reasons, I didn't speak much about my work. I mean, I didn't share it with anybody. I didn't even share it with my own mother. But I did continue to see the union protect workers that were not doing their jobs. And I just couldn't understand how that happens, how you can protect somebody that just simply is not doing their work. I also saw how they lobbied workers in the break room about what they called contract negotiations, but it was more like a get out the vote party for the political candidates that the union supported and endorsed. Finally, on September 28th of 2017, I received a text that the Supreme Court had accepted my case to be heard for oral arguments. I mean, I was excited. I mean, I was also very, very nervous. I immediately knew that there would be possible ramifications at work. I mean, I wasn't concerned about losing my job, but I was uncertain about the presence at work, and that once the word got out, how my fellow workers would view what I had done. I mean, going to the Supreme Court. So I learned after a few days that I had quite a few supporters, very quietly, under the radar, if you will. They would come up to my desk and they would say, "Thanks for doing what you're doing. and they would thank me for stepping up, and they wish that, they could have done the same thing. You know, but I was surprised that there were so many fellow workers, that were strong union supporters, and they didn't like anything about me. They passed me in the hallway and they'd kind of give me that evil eye. They wouldn't even speak to me. I mean, they pretended I didn't even exist. And not only was it cold outside as the winter progressed, but it was pretty cold inside, and I was shunned, by the union supporters. Finally, word was received that the oral argument date was set and that they would hear the case on February the 26th of 2018. Well, going to Washington and walking up the steps of that Supreme Court building, is quite an experience, let me tell you. And entering the majestic Supreme Court chambers themselves in the courtroom is just unbelievable. It is so majestic. And even more surreal was hearing my name called by the Chief Justice as the case was called. And believe me, I was nervous. Now, I was sitting in the gallery, just like everybody else. And in the Supreme Court, if you have a case, even as a plaintiff, you do not testify and you do not speak on your own behalf. I mean, that was the job of my attorneys. It was their job to speak for me and present the case. Also, the Supreme Court's very much like a debate. You don't have a jury. They don't call witnesses. The lawyers begin their presentation and their arguments, if you will, and the justices would interrupt and ask questions or ask for clarification. And at times it was very clear where the justice would stand and what they believed, and you could kind of figure out, what they were striving for. But at the conclusion, you still really don't know, because the court is the court. And until they render a decision, you just really don't know. So we filed out of the courtroom, down the steps, and there was a throng of media. I mean, there was the major television networks. I mean, there was radio, there were photographers snapping pictures all over the place. They were following me everywhere. And I never saw so many microphones in my life. And, afterwards, when I returned to Springfield, I returned to work. And now the waiting began again. When would they render a decision? Now, my lawyers told me, and some of the other pundits that follow the Supreme Court very, very strongly, they thought I had a good chance of winning, but still, you just don't know. You just don't have an idea. Finally, the court term was ending, which was the end of June of 18. And, even as a plaintiff, I don't get a heads up as to when they're going to announce their decision. You just don't know. So we went to Washington that final week of the court term, and we sat in the courtroom on Monday, no decision. We came back on Tuesday, still, again, no decision. We went back on Wednesday, which was June 27th of 2018. And in a way, it kind of felt like Groundhog Day, the same thing happening day after day. But it was that day on June 27th of 18 that the court called the case. Justice Alito read, the opinion, and we were all ecstatic. I mean, I was just beside myself that I had actually won a case in the Supreme Court. And what that decision did was it gave right to work basically for every public sector worker across the nation, all 50 states. It gave freedom to over 5 million public sector workers. It gave workers the right to hold their government jobs without having to pay a union for that right. It gave workers the right to not support a public sector union, but at the same time, it also gave them the ability to support it if they so choose. In other words, it gave the worker the right to choose for himself. So after the ruling, I went back to my job at the state. And of course, I was a bit apprehensive. I mean, I wasn't sure of how my fellow, workers were going to react and so on. But I was very happy to know that there were a lot of them, again, very quietly, under the radar, came to my desk and said, thank you. Thank you for what I had done. They appreciated the fact that they now had a right and they had that ability to make their own decision. And it made me feel very good. Conversely, the strong union people, again, just totally ignored me. And of course, then the news media and everything else, the union started putting out the word and the like, and things got a little bit strange, let's put it that way. But I also learned very quickly that the unions were not going to pack up and go away. They weren't going to take this line down, no way. And they began to frame this whole case as anti-union, anti-worker. And of course, they framed it in such a way that all collective bargaining would come to an end. I mean, I thought that was just totally ludicrous, but that's what they said and that's what they were doing. So I retired from the state and joined Liberty Justice Center to advocate for workers' rights full-time. And it didn't take long before we began hearing from all kinds of people all across the country who were trying to exercise their new, what they now call Janus rights, but couldn't. Unions were not allowing people to exit or resign or opt out of their union membership. And what they were using were what they called so-called opt-out windows, just to keep workers paying dues, to keep the money flowing. And if you're not familiar with opt-out windows, an opt-out window is a time frame where the worker has only a very limited time, it could be as short as 10 days, to resign their membership, only at a certain time of the year. And many times that window is very, very confusing. It could be between 45 and 15 days before your annual membership anniversary. And sometimes your anniversary date is different than what your actual joining of the state or your first day on the job is. And if you went to ask the union for an anniversary date, because you may not have kept track of that and don't know it, all you heard back from the union was crickets. They wouldn't tell you, and some unions were saying you had to send them a certified letter for resignation, but then they wouldn't accept the certified letter and it would be returned to sender. So basically, going backwards on your resignation, saying that, we're not going to accept your resignation, even if you do mail it to us. And they just used all kinds of tactics that were just, quite frankly, abominable in my case. But what the unions were doing were denying people their constitutional rights and their freedom of association under the First Amendment. And that's the bottom line. I mean, these opt-out windows only gave these people their constitutional rights for, let's say, 2 weeks out of 52. So does that mean you're denied your constitutional rights for 50 weeks out of the year? I mean, that's just, I think, just unconscionable myself, but that's what they were doing. So it was, clear that government unions and politicians stood in the way of these people from resigning. And that the unions were fighting to maintain this membership any way they could. They wanted to keep that money flowing. They wanted to keep their monopoly. And they want to maintain those dues. They want to keep that membership roll. And, in so many cases, we found they were not wanting to represent the worker, because we heard from workers that said that they had tried to work with the union and basically were ignored. And we've also seen the unions and their politicians use their political power to try to circumvent that Supreme Court decision. For example, in California, Senate Bill 866 that was signed into law on the day of the Supreme Court decision, that June 27th of 18, by then Governor Brown, where it thwarted government workers' right to exercise their Janus rights. And how did they do that? Well, they barred employers, managers or supervisors, and or the HR department in that public agency from discussing an employee's Janus rights. In essence, it's a gag law. If an employee goes to their supervisor, and says, hey, I want to hear about this Janus rights and, I want to resign from the union, that supervisor cannot even discuss it under penalty of law. They have to tell the individual to go to the union for answers. Well, does anyone think that that's going to work in the employee's favor? Will they receive truthful information? Now, we've also seen 100 pieces of legislation introduced to circumvent the Janus decision, and that was in 2019 alone. We've also seen captive or mandatory new hire meetings, where the union is the outside sole representative presented into that new HR orientation. These meetings give the union the sole platform to pitch membership. Is there competing information presented to let the workers know that they do not have to join? Nope. It's all one-sided. It's all slanted in the union's favor. Fortunately, in my role at the Liberty Justice Center, my work to help government employees exercise their rights continues. Since the decision in my case, we've heard from over 1,500 government workers, and we believe this is only a small fraction of the people trying to resign, because we think that there's an awful lot of people out there that have tried to resign and they've just simply given up because they've hit these opt-out windows, they've hit these other obstacles, and they've just given up. They're just frustrated and just give up. Now, we also have seen some other tactics that the unions have used. We had some cafeteria workers in Massachusetts where the union came in to try to organize these public sector cafeteria workers. And this was before the Janus decision. And if the workers wanted to hear or learn some more information, they just kind of signed their name, and the union promised to send them additional information because all they wanted was additional info. They just wanted to learn more. Well, guess what? Now the union says that they're members and they have to wait for an opt-out window to resign their membership. Never mind that they never signed up to be a member of the union. They just wanted information. But that's what these folks are doing. That's what these unions are doing to maintain their memberships and make it grow. We've seen government workers in Maryland and Washington that have contacted the union to resign. And the union says, okay, you're out, you're resigned, you're not a member of the union anymore. But guess what? They're still collecting dues. And when they've asked for a refund of the dues that have been collected illegally, they don't get the money back. And it's just basically, again, crickets. But now let me tell you about a couple of specific people that we're helping that I think you'll find very interesting. We have Ariadna Ramon Barrow. She's a teacher in the Waukegan School District, which is about 40 miles north of Chicago. And Miss Barrow is from Spain, and she's visiting here on a 3-year cultural education exchange for educators. So Miss Barrow is completely new to the U.S. public education system. She just is not familiar with it. But at a new employee orientation, Miss Barrow was not informed that teacher union membership was optional and that dues were optional under the Janus decision. In fact, a union representative sent an email to many of the teachers in her school district. And let me tell you what he said, and I'll quote, "You will pay union dues regardless of whether or not you are a member." Well, under the Janus decision, this is just blatantly illegal. This should never have occurred. So Ms. Barrow is fighting for her right to serve students without being a union member. She's also fighting to get her money back. that she says, and we agree with her, that the union took illegally, that she was forced to pay these dues. That strictly goes against the Supreme Court decision. And Ms. Barrow has even made a public service announcement type of video that is out on the internet in order to be able to inform other government workers, especially teachers, of their Janus rights, that they do not have to pay a union to hold their job and be a member of the union. Now, we have another worker that we're helping and her name is Kara O'Callahan. Kara is a sports club finance manager at the University of California, Santa Barbara. She joined the Teamsters Union only weeks before the Janus decision, and she joined because of the pressure that she got from a union representative. I mean, this person basically hounded her to join, and she gave in. Well, she was surprised and upset to find out that after being a non-union member for years and years, that she joined the union right before her non-member fees would have stopped anyway due to the Janus decision. I mean, she felt duped and she felt taken advantage of. And so she quickly tried to resign on her own, but in a response from the Teamsters Union, they said that she was out of the union. But the union said that she still had to continue to pay what they called a service fee. Yes, that's right. They called it a service fee until the end of the collective bargaining agreement, which was March of 2023. So she still has to pay, even though she's not a member. And again, that goes against the Supreme Court decision. Now, Kara's been profiled in the Wall Street Journal, and she's participated in a video to tell her story. And she's very committed to seeing this case through to the end. And this case will soon be before the Ninth Circuit Court of Appeals. Now, myself, I'm continuing my fight with AFSCME, which is the American Federation of State, County, and Municipal Employees. I'm still working to get back my fees that I was forced to pay. My case is currently waiting to be considered by the U.S. Supreme Court. It's scheduled for a conference this fall, and the justices will decide whether to hear the case or not. And Liberty Justice Center is representing me again, and the case could determine whether public employees will be refunded hundreds of millions of dollars in union dues taken against their will. Within the decision issued by the Supreme Court in June of 18, the court agreed that taking money from members was wrong. And all I want is the money they illegally took from my paycheck. You know, it's not the money, it's the principle. What they took was wrong, and it's the principle, the fact that I want this corrected. Now, Liberty Justice Center is also representing government workers who paid illegal non-member union fees, and we have 7 class action lawsuits currently going at the same time. Now, that's why I work every day to inform government workers that they have Janus rights. They don't have to join the union. We cannot give up. We've got to be vigilant in letting workers know that they have Janus rights, and they have a First Amendment right of disassociation with the union. But unions don't want them to know that. And our fight continues until the day exercising these rights is as easy and simple for everybody. It's just checking a box on a form. You know, very, very simple. I find it very interesting that you can check a box on a union website to join, but if you want to resign, you have certified letters, you have windows, you have all kinds of hoops you've got to run through. Very, very interesting, I think, anyway. But we have to remember that workers now have choice and they have the voice to decide their own path. It's up to the individual worker. But Liberty Justice Center is not just involved in worker freedom. We currently represent Palmetto Promise in South Carolina, in a case called Adams versus South Carolina. Now, in July, Governor McMaster said he was going to use $32 million received in governor's emergency education relief funding to provide one-time scholarships for students to attend a private school of their choice for this coming school year. Now, the basis for his decision is to help low-income students attend the school of their choice. And to date, there are over 10,000 parents who've shown interest in the program. 10,000. I would say that's a very high percentage of people that are interested in this program. Now, this may come as a surprise to you, but the plaintiffs in this case that are fighting to get this scholarship program shut down are all related to the teachers union. They want to stop this program. Now, there is some hope on the horizon, though. In August of 2019, Alaska Attorney General Kevin Clarkson issued a legal opinion arguing that the state of Alaska wasn't in compliance with the Supreme Court decision. Subsequently, Governor Mike Dunleavy ordered the state to create a system for public employees to opt out of union dues and agency fees. Naturally, the public sector unions went to court to fight. They've got an injunction, and Liberty Justice Center is a party to the defense of Governor Dunleavy's order. We also have Texas Attorney General Ken Paxton, who's also issued an opinion, finding that it's not enough for government workers to have signed a one-time dues deduction form, but in his opinion, he urged the creation of a yearly authorization form, essentially mitigating the union opt-out windows that at best are difficult to understand and keep workers paying dues even when they don't want to. Now, in June of this year, Indiana Attorney General Curtis Hill Jr. issued his opinion that employees must collect annual, and I quote, clear and compelling evidence that an employee has voluntarily, knowingly, and intelligently waived his or her First Amendment rights and consented to a deduction from his or her wages. Now, this language was written in the SCOTUS decision in my case, came right out of the decision. In Michigan, which is a right-to-work state, the Civil Service Commission issued a ruling stating that employees and employers, not unions, must now obtain direct consent from the employee before union dues can be deducted from their paychecks. All of the above is long overdue. Workers should have the right and the decision-making power on their union involvement, not some third party, which is the union. In short, give the power back to the worker. Let the worker decide for themselves, not the union. I want to thank you again for the honor of speaking with you today. Thank you for all your support for liberty and worker rights across this great country of ours. Thank you.
Well, welcome, Mark. It's so glad to have you with us, and thanks so much for that talk. It's just really exciting to just hear about your journey, not only how the whole court case proceeded and unfolded and your experiences in that process, but also the things that you've been doing since then to make sure that the outcome of the case and the importance of workers' rights and their ability to make a choice gets spread around all workers being aware that they can choose. So I just have a few questions I'd like to ask you and just get your feedback, maybe dive in a little deeper to some of the things you mentioned in your lecture. And then we'll also be receiving some comments on Facebook Live as well as others that come in. So I will be using my phone to receive and sift through those and ask some of those questions as well. So I guess, maybe I'd like to begin with the general question that some people would hear the case and listen to the outcome and say, well, this was just nothing but an anti-union effort, that there's something just intrinsically opposed to unions. And how do you respond to that? You obviously touched on it a little bit in your lecture, but could you elaborate and how would you respond to those claims?
Well, I have to respond in the fact that it's not anti-union whatsoever. It very strongly leans in the direction of just giving workers the freedom to make their own decision. And by giving the worker their choice and their voice, let the worker decide for themselves. Let's not make it a mandatory situation for that worker to have to pay money to hold their jobs and keep employed by a government entity, whether that be the federal, the state, or the local.
Absolutely. It's interesting, I suppose, on the one hand, if individuals are then given that choice and it's clear to them that they have the choice, then it's incumbent upon the unions to make their case that they are going to provide services that warrant their membership. Isn't that the case?
Oh, absolutely, absolutely. And it's up to the union, like it is to any other organization, to make the case to that individual as to what is in the individual's best interest, to whether to join or not join, whatever organization it might be.
Absolutely. One thing that I reflected on a little bit more, as I understand it, Franklin Delano Roosevelt once made the distinction between the public and the private unions, and indicated that public unions, really there isn't a place for the public sector to be unionized for some understandable concerns. And so when we think about your particular case, that is also an important distinction. Compulsory agency fees for individuals that are part of a public union. Could you elaborate on that and why the public-private distinction is actually an important one to make?
Well, I think the distinction you have to make is that in the public sector, there is a component that's left out of the negotiations, between an administration and that union, and that's the taxpayer. Because in the private sector, you basically have two parties. You've got the management or the owners of a business along with the union, and the two work together. But in the public sector, you have that third component, which is the taxpayer. And you have to take a look at the fact of who's actually representing the taxpayer and what is in the best interest of that group of individuals that have to pay the bill, whatever the outcome of that negotiation is.
So you have that asymmetry, that inherent asymmetry, where in the public sector, individuals just don't have the opportunity, that is the taxpayer, to have their voice heard. I suppose that many would say it becomes a mutual back-scratching exercise between the elected politicians who are supportive of unions and then the unions doing what they can to ensure those individuals get into office to support their cause. Makes it an easy negotiation.
Absolutely, because that's why, as part of our arguments that we made at the Supreme Court, we pretty much said that the unions are pretty much a political organization. And Alito said so much in his opinion, his affirmative opinion that he gave us, that these organizations are political in nature, just by the very nature of what they do and how they operate.
Do you suppose, because the Supreme Court had made that distinction and clarification that they're inherently political, do you suppose that in many respects will inoculate future arguments? So I think in terms of, I think it was the Abood case where a distinction was made between the agency fees and full membership fees. And as long as we sort of separated the political activity from the representative activity, that would be okay. Alito's opinions, as you indicated, said, no, this is an inherently political activity. Do you think that will inoculate future challenges? Because I'm sure that the unions would love to see something change again in the next decade or so, back to the old way.
Well, I'm not an attorney, so that's a very good question. I would have to think that, there will probably be some kind of a challenge, maybe somewhere down the road, but that's not for me to respond to, just because who knows what will happen down the horizon.
Well, I personally found the reasoning quite compelling. We'll see if others, if it's ever challenged in the future, will look to that decision and say, indeed, that decision stands. Now, of course, as you noted in your lecture, you aren't just standing, right? There are things that you and the Liberty Justice Center are continuing to do to make sure that individuals are aware of their rights. And so I'm wondering, you noted several instances in your lecture of where apparent obstacles or deliberate obstacles are being put up by the unions to getting the message out. And how do you feel that you are proceeding and progressing in getting the word out and helping individuals understand that they actually now have the right not to be part of a public sector union?
Well, we're doing a lot of publicity, advertising, We're trying to work with other organizations across the country. And it's a tough road to hoe because you have the unions that, have that, how shall I say it, captive audience, if you will, at that work, in which I described as part of my lecture, where if you were a new hire, you walk into that new hire orientation, you've got the union sitting there telling you all about the union, how important it is to join, and nobody ever says that you don't have to join.
Right.
And that there are such things as Janus rights. You've got California, where if you go into your supervisor or manager and ask about it, they can't even talk to you about it. So therefore, that supervisor or manager will then send you to the union to get information. Can't say that would be, totally objective, and would, go in the employee's favor. But it's just a matter of as we find out, that people are learning about it, the word is spreading mouth, and among the peers, and they're finding that a lot of people are saying, look, we're going to rethink this and the ability to join or not join. Yes.
Well, that's good. I do have a question now. I'm going to transition to a question that comes in from our audience, and the question is this. Mr. Janus, thank you for doing all you did to free so many from being forced to subsidize speech that they do not want to support. I'm a member of a profession who has not yet benefited from the holding in your case. I'm a lawyer, and like all lawyers, I am forced to pay dues that subsidize the speech and political activities of my mandatory state bar. What kind of fortitude and strength of character is needed for someone in my profession to fight the kind of fight that you fought and won?
Well, Liberty Justice Center currently has a case in Wisconsin to answer that very question, where we are litigating the mandatory, bar dues, and we hope to, hopefully we'll win, and that state bar dues, may become an option, just like it has in the public sector union area. It just takes individuals to stand up and say, look, this isn't right, I don't believe in it, and file a case and begin the proceedings. If you're in the public sector, we encourage people to go to our website, which is standwithworkers.org, and learn about what your rights are, and step up, and hopefully we can help you in that regard.
Well, thank you for that. Reflecting a little bit more on the words fortitude that the individual asked, I reflected on your own experience, where I think you had remarked that it was cold weather outside and cold inside, that there was, that took some sort of fortitude to be able to move forward with your case in spite of knowing that there was quiet opposition. But then you also did get some individuals who, as you said, indicated quiet support for your position. How did that encourage you to know that there were others out there who were, silently supportive, largely, of your cause?
Well, it was very encouraging to know that I had that silent support. And I would get emails from people across the country once they learned about the case. I would get notes and cards, saying thank you for the fortitude, if you will, to stand up and fight back against these very powerful unions. And it did give me the how shall I say, the encouragement, because with all of the negative that was coming down in so many different areas, it could get discouraging, but I didn't allow it.
And did you have individuals who were overtly opposed to you in the workplace, or was it largely just the quiet treatment?
Oh no, it was overt.
Yes,
it was overt. We had people, that were strong union people that shunned me.
Yep.
We had, union people that just wouldn't speak to me, and the like. And it was kind of funny when I retired from the state of Illinois, and I was getting close to my last day at work. The union had a retirement party for me, which they had a cake which had the colors of the union. And they put on Facebook and said, well, happy retirement, but since you're not a member of the union, we can't invite you to this party.
Oh my.
I thought was a bit childish, if you will, that they would go to that effect. But that's
Right.
one of the things that they try to drive home, that, that part or that point, I should say.
A not so subtle message in that, right?
Exactly, right.
Well, when you did have individuals, whether they would contact you by email or just quietly in the workplace indicated they supported what you were doing, did that give you any sense of what might transpire after the case, assuming that you obtained victory at the Supreme Court, about how many individuals would actually then seek to exit the union once that decision was made? Some statistics, and it's tough to necessarily measure how many individuals have left a public sector union, but various estimates since 2017 to 2019 indicate that anywhere from 3% of public sector union individuals have left, to as high as possibly 13% in the case of the state of California in one study that I had read. So do those numbers seem like what you had thought might transpire on the other side of the case, assuming victory?
Well, quite frankly, I wasn't sure what was going to happen as far as actual numbers go. But you also have to remember that some of these figures, the decision came in June of 18. And of course, there's always a lag period, when the unions have to submit their different annual reports. And of course, what I also found very interesting is that as we kind of got more into this and started looking at some of those numbers, that some of those numbers were definitely fudged, if you will. And I used more publicity type figures than actual true numbers. And it's still going to be very, very difficult based on the, how shall I say, lack of transparency at times that the union has in some of their reporting requirements and how they do that. But I think overall, we're very encouraged by the efforts that have already been started, like in Alaska and Texas and Indiana, and of course your home state there in Michigan, where I think once the word gets out and as people learn that they have their ability to decide for themselves, they'll take another look at it. And I think the fact that you have to then potentially opt in to the union, which is what the Supreme Court decision said, I think that's another component versus you may have signed a membership card 20 years ago, but maybe your views have changed. And now to try to get out, as I pointed out, you have these opt-out windows and these other impediments to resigning.
Right. That's very interesting. I didn't think about that, the whole opt-in issue, and that there's, I suppose, to some degree, some inertia where individuals might otherwise take action, but the inertia just keeps them going in the status quo. But I bet you might see as new individuals are presented with the opportunity, at least insofar as they're aware of the choice, that you might see fewer people signing up because, of course, before it was compulsory, but now this new generation coming in with the opt-in would have to deliberately choose, as the Supreme Court indicated. So I suppose...
Well, I also think you have to remember that in many cases when these unions were put into the workplace many, many years ago, you have to look at how many of those people actually initially voted, to unionize and begin that portion of the process. And I think if you'd start looking right now, you'd find that there's a very small percentage of those people that actually did vote and that did actually ask for, that union representation.
Oh, that's interesting.
Number of numbers across the country that vary all over the place, but it's quite surprising that many of those people that initially wanted the union have now retired and gone on, but yet we still have the union in that workplace.
Yes, very good point. Didn't think about that. Didn't realize the small percentage of individuals who would have voluntarily from the get-go enter the union, and they were just in there by compulsion. So I have another question then that comes from our audience, and the question is this: what was the most challenging part about bringing a case like this before the Supreme Court? And other than the victory at the end, what was the most rewarding?
Wow. I would say the most challenging part was initially trying to figure out how I could bring a case and what would be the path to take in order to get a case started. Because I'm just a single individual, and how do you basically go up against a Goliath, if you will? And once I found Liberty Justice Center, and which I learned about, and found out that they're a public interest law firm, and they vote for, and they work for the cause. They don't work for money, they don't work for special interest. And I found them, and I was very, very grateful. That was, I think, the challenging part. Of course, once I found them and we began the dialogue and they agreed to take the case, that became much less of a burden. Once we received the decision, quite frankly, I was ecstatic, because who would ever think that they would go all the way to the Supreme Court? I never did. I mean, even in, I think everybody tries to plan ahead, but who could have thought that it would have gone in this direction, and that we would now have this monumental decision that gives worker freedom, and the fact that we now have to fight to continue that worker freedom, which you would think would be somewhat automatic in a way. But I think we have to realize that, if we do not support and we do not fight for our First Amendment rights and our other rights as guaranteed by the Bill of Rights, we're going to lose those rights. And we need to continue to support those every single day of our lives.
Absolutely. So, and you've mentioned earlier some states where there have been significant progress. I think Texas was one of the examples that you cited, where there's annual renewal that is expected for affirming membership. And then, of course, you have the other extreme of California that effectively gags information from getting to individual workers. Do you think that this court case then, and the outcome, is really then going to descend into state politics, where the individual state, red or blue, or however you wish to describe it, is either going to allow unions to be more, create more obstacles, and other states that are more favorable towards the decision will allow the information to be easily disseminated to workers? Do you think that's what this is going to come to?
I think it will, because I think you're already seeing where in some cases, it's very easy to join the union. You can check a box on online at a website, but if you want to resign your membership and get out of the union, you have to write a letter. It has to have a certain amount of language to it. It has to be within a certain time frame. It has to be mailed to a certain address within that time frame. And as I stated, some unions are saying it has to be certified, but then they won't accept the certified letter.
Oh my!
In essence, negating your efforts to try to resign. So I think it needs to be in such a way that you have that right to exercise your worker freedom by simply checking a box. Yes, I do. No, I don't. Very, very simply. Very much like what we do so many other things in the country right now, that we make things much easier because of the internet and so on. It would be nice if we would get to that point.
That's right. Make your case. Have the unions, make the case and allow others to express the other side of what the benefits and pros and cons of joining or not joining, and let the decision fall on the worker to make it on the basis of those merits, right?
And that's all my case does. It just gives the worker that choice and the voice to make that decision on their own, not some other party that mandates that in order to have a job, you have to pay a fee or pay some dues.
Exactly.
That's that I think is very frustrating.
Sure, absolutely. I have another question then that has just come in from our audience. And the question is this: how did you deal with the treatment you received from the other union members during and after this case? How did you deal with that treatment?
Well, basically, I think I just had to hold my head up high and realize that these individuals, have a point of view. Mm-hmm. And even though I don't agree with it, I'm not going to, cast disparaging remarks in their direction, because they obviously have a belief and they're entitled to that belief.
Sure.
I have a belief and I'm entitled to mine. And let's say we agree to disagree. And in essence, depending on how it was proposed or how it was put forth, I would either just kind of shake my head, or I'd say, well, that's just the way it is.
Sure. Wouldn't it be nice if there were many more instances of people in society today that agree to disagree and be civil about it? Unfortunately, it seems like sometimes that doesn't occur as we would like. You know, we're getting close to the top of the hour, so I wanted to ask you to elaborate a little bit more, as you have already, about where you're going from here. In other words, there's still things to be pursued in terms of making workers aware, but also I understand that there's some cases pending in terms of whether or not workers should be reimbursed fees that they had been charged when they had not freely chosen to join the union. Can you elaborate on some of those efforts?
Yeah, well, I mean, I'm currently pursuing a case with AFSCME and Liberty Justice Center as my attorneys to try to get back, the dues that I paid, that they collected, that the Supreme Court said was wrong. And it's the principle of the thing. It's not the amount of money that I'm concerned about. It's the fact that we asked them, to stop withholding when we filed our original case. And they chose not to do that. They chose to keep it and spend it, versus putting in escrow or let's wait and see what the outcome is. But we have 13 other cases, that we're litigating, that are enforcement cases, if you will, for Janus rights. But we also have several class action suits that are very similar to mine, where we're trying to get people's dues back, get the money returned that they were illegally kept. And I think, as I already told you, we have some individuals that have contacted us where the union said, yeah, you're resigned, you're out of the union, but you still have to pay a service fee. So it's the semantics of they're saying, well, it's not an agency fee anymore, it's now a service fee.
Oh my.
Again, trying to get around things. But it's just going to be a long process. We've just got to continue the efforts to get the word out to people, to make people aware that they have these rights, like we have so many other rights. And it's a matter of continuing that effort. And, whether it's spread by word of mouth, whether it be spread by op-eds and, media, Facebook ads, whatever the case might be. All we're asking is to make people aware of what they can do. And that's, again, why Liberty Justice Center is doing what it's doing and why I'm doing what I'm doing to get this word out in forums such as this with Acton, but also for the website that we have, standwithworkers.org, to, if people want to find out what their rights are, they can go to that website, learn about what their rights are, and then they can make up their own decision.
Well, that's terrific. It's such a pleasure to be able to chat with you, and your case is inspiring for all of those who believe in freedom of association as our Constitution provides it, and knows that they have a choice to be able to join or not to join a union. And so it's a delight to hear about your story, as well as the activities that you continue to do to stand on these principles and to convey those messages to the American workers. So thank you so much for joining us, Mark. It's been a pleasure chatting with you.
Oh, it's been a pleasure. I'm so happy that you invited me to present my case, if you will.
Terrific. And thank you, audience, for joining us, and we look forward to you joining us at our next Acton Lecture Series. Have a great day.